none of this gives me any more confidence that the conviction is valid.
Well, Your Honors...
And the prosecutor's job is to do more than secure convictions and in your office to maintain them. I mean, you're ultimately trying to do justice. The trial court judge, I don't even know who it is, let alone know he or she, but reacted strongly to the circumstances. Now, I respect the Court of Appeal, and they reversed, and without advocacy from counsel, because the counsel didn't have the records, concluded that the records were not helpful. And that's the state of affairs as we have it. But I have to say, from what I've seen, this conviction was not based on overpowering evidence. And so there's a grudging concern. Gee, were there things that if the jury had known about, it all hung on the testimony of the one witness, if there are things the jury had known about, would that conviction, would that verdict, guilty verdict, have resulted? There's a question. And what I've heard from you so far is a set of procedural obstacles which Mr. Gage, pro se, failed to clear. And that's true, and that's what the law provides. But none of them give me any confidence that the conviction should be sustained in any broader sense. Is there a reason why we should have confidence that this is a valid conviction? I mean, think about it. If you had, let's take the case as presented to us by petitioner. Is it true, in your view, that the conviction rested entirely upon the testimony of the stepdaughter?
It's my understanding that there was no, that the evidence was the testimony of the witnesses due to the time between the between the time of the actions and the time of the trial.
I mean, that's the reality in many of these cases, and I understand that. And the prosecutor, it's he says, she says, and the jury has to decide. And that appears to be what happened here. Well, the trial judge at least reported that those records that have been denied defense counsel reported that the mother identified the stepdaughter, her daughter, as a pathological liar. Isn't that something you think the jury might be affected by?
It seems that would be something the jury would take into consideration.
Doesn't that make a classic Brady material?
If Your Honor, but again, Your Honor, that was known to the petitioner way back when.
See, now you're giving me to the procedural obstacles again. I'm trying to ask you about the conviction. Doesn't that sound like classic Brady material?
Your Honor, based on this record, it is not clearly Brady material. If it were, then why did the justices of the Court of Appeal deny?
So we're left basically, the state's case is that we've got to take the say-so of the state Court of Appeal judges who made their decision without advocacy from defense counsel because defense counsel didn't have access to the records in question. Doesn't that trouble you in some fashion? It troubles me. It may be that we can't do anything about it because of the procedural limitations, but I got to say, it doesn't give me a lot of confidence in the verdict. Does it give you a lot of confidence in the verdict?
Your Honor, I'm not here to question I'm not here being asked to...
On some level you are, because the state of California, I mean, there are classic quotations about the prosecutor's job is not simply to obtain convictions, it's to do justice. And I've had other cases where, to its credit, the state attorney general's office and the local prosecutors, after they've successfully convicted and incarcerated somebody, have decided, you know, there's something wrong here, and wound up undoing what was done. So I hear what you're saying. Your job today is to advocate for a position which isn't the position that I'm talking about. But in the big picture, I have some concerns about this conviction, and I would hope the state of California would have some concerns as well.
Well, Your Honor, I personally don't want you to think that I'm standing here blithely disregarding everything you have to say. Believe me, I'm not. And I will go back to my office today and I'll have a conversation with my supervisor over how to proceed. And as you are familiar with my office, there's a chain of command, and I will bring it to my supervisor's attention. I have personally not seen these records. All I know is of what is in the record itself. I came into the case for purposes of this argument, And so I want...
And you have to play the card you're dealt. I want you to understand, I'm not faulting you individually, but right now the system seems to have worked in a way that at least raises questions.
Well, if I may, Your Honor, and I still have a few minutes, if I may, to address your concerns about the system of justice in this case, the records were produced to the trial court. The records were produced to all of the state courts.
I know that, but as I said, Mr. Cook, that was ex parte. Why weren't they produced to the defendant?
The prosecutor took a position which is reflected in the record, and if the I don't know why the trial court didn't order that. I don't know.
Well, he didn't get them until after the verdict came in. I mean, you read the trial court's order raising questions and expressing surprise at the verdict that the jury could have believed the key witnesses, and then it appears the trial judge gets the records and orders a new trial. So of the 4 people we know saw those records, the trial judge, the 3 judges in the State Court of Appeal, at least one of them responded strongly and gave us the few clues we have as to what they contain, the reference to pathological liar and so forth. And all of this is done without defense counsel having an ability to go through and, this is an advocacy system. Depend on hearing from both sides. They don't just give us the material. We're not the magistrate, whatever, the inquisitive type system. And so, accepting in good faith that the judges on the Court of Appeal look at it and say, no, we don't think there's anything here that would have made a difference. That perspective could be different. That conclusion could be different if they'd heard from somebody who could advocate saying, well, look at this and this and this, and I can connect it up with this and so forth. So I don't know why the trial court didn't order their production, but it's clear the trial court didn't see it himself or herself until after the trial was over. Doesn't that seem odd? I mean, if it's evidence that would speak to the credibility of the key witness, ordinarily that's material that's turned over.
I don't know the thought processes of what went into all of the judges and justices. However, at this point, in prior arguments that I have made to this court, I have been also told to limit my arguments to the issues before the court. And at this point, again, I'm not saying this to be blithely disregarding of your comments and your concerns. And as I said, and I'm a man of my word, I will go back to my supervisor and I will convey all this. If he is not already listening via the internet.
That's true. Hello there.